So the goal of today's presentation is going to be to provide you with some insight into the types of personal injuries that you may face in both your personal and professional lives, and to provide you with a brief introduction on the legal landscape as it relates to those injuries. Personal injury will have application to your personal, your professional, and your patient-centered practice. So professionally, the nature of the calls that you're going on are going to place you at an increased risk of injury. This may be environmental or situational in nature. You might be attending, for example, a motor vehicle collision scene that involves driving to the scene under lights and sirens at increased speed. You might have to navigate properties that are in disrepair or inadequately maintained, for example. And even when you're outside of work and you're injured, it's important to realize that this can still have a significant impact on your ability to continue working and on your income, on your activities of daily living, on household and recreational tasks, and on your physical and your emotional well-being. So injuries also can happen to your family members. They're obviously not just restricted to the membership and to paramedics. Today's informative session is also designed to provide some insight in that context as well. So from a patient care standpoint, finally, you'll often attend scenes that do involve some sort of injury. So whether that is a car accident, whether that is a fall, your documentation and your care for the patient do play a vital role in the trajectory of their treatment and the outcome of their final claims if they pursue the claim process, or litigation if they pursue litigation. So it's important to understand your role in that and how we look at certain documents that are produced as you go along and provide patient care. Conversely, paramedics are also providing controlled medical acts and you're administering medications. So you are also susceptible to a risk of claims being brought against you by individuals or family members alleging injuries being caused or contributed to by your actions. So it is also important to understand that element and how you can protect yourself and alleviate some of that risk. So the first one, which is one of the big ones, is motor vehicle collision. So there's two types of streams of recovery that you can fall under when you have a motor vehicle collision in Ontario. One of the avenues of recovery is the statutory accident benefits scheme. This is a mandatory no-fault insurance that's included in standard Ontario automobile policies. So your personal policy will also have access to statutory accident benefits. These benefits are governed by the Statutory Accident Benefits Schedule. It's contained in the Insurance Act. So it's going to provide benefits to individuals that are injured in motor vehicle collisions as regardless of fault. So whether you're at fault or not, this system would be available. There's three classes of injuries that are typically allotted within this system. So the first one is the minor injury. Typically on a standard policy, that'll give you medical rehabilitation benefits in the area of $3,500. Then there's a non-catastrophic but non-minor category. That includes medical and rehabilitation and attendant care benefits up to a maximum of approximately $65,000 over 5 years. Now, when I say eligibility for benefits, that's not going to be a check in your pocket for $65,000. That's going to mean that you are entitled to claim benefits up to that amount over the span of 5 years. And then the third category is the catastrophic category. So medical and rehabilitation benefits and attendant care benefits under that category, you can claim up to $1 million. There's also other benefits like housekeeping benefits, caregiver benefits. And then there's also optional insurance, which I'll briefly go over as well. So there's various types of benefits you can claim under the accident benefits system. Some of those may or may not be applicable to you in your specific situation or your family member's specific situation. But some of these benefits are medical and rehabilitation benefits, as I've mentioned before. That's basically your treatment. So if you need to go to physiotherapy, see a chiro, massage therapy, psychological treatment. Those are all covered under medical and rehabilitation benefits. Then there's also attendant care benefits. These are available for non-minor or catastrophic injuries. So these are meant to provide care for individuals who need it after an accident. There's also different forms of income replacement that could be potentially available under accident benefits. There's essentially 3 different types. The standard one that would be applicable to an employee would be an income replacement benefit. It's candidly not a lot, and it wouldn't cover the types of income and salary that paramedics make. So it's the standard policy of insurance. That benefit is about $400 a week. And then you also have to establish that you have a substantial inability to perform the tasks of your own employment. So that is the test that you have to meet for the first 2 years after you're involved in a car accident and injured. After those first 2 years, the test then changes and it becomes a complete inability to engage in any employment to which you're reasonably suited by education, training, or experience. So we'll usually start to see denials around the 2-year mark if somebody has been unable to perform the duties of their own employment, but they're deemed to be able to work in another capacity. Another benefit that could potentially be available is the non-earner benefit. That is for individuals who are not in receipt of income, who are not working at the time of the accident, so maybe a retiree, for example. To qualify for this benefit, you have to show a complete inability to carry on a normal life. It is less than the income replacement benefit. It is $185 a week, approximately, less any other income replacement you might be receiving. And for this one, there's a 4-week waiting period. Non-earner benefit is payable for up to 2 years after an accident. And like I said, retirees typically would apply for this benefit. Full-time students, they could apply for that benefit, or individuals on disability. And then finally, there's also a caregiver benefit. So this one is available to injured individuals that are not able to provide care as a primary caregiver, such as if you have dependent children or dependent parents. This benefit is paid at approximately $250 a week, plus $50 for each additional person in need of care. And it is only available for catastrophically injured individuals, or if you purchase it as an optional insurance. So a standard policy will not carry the caregiver benefit other than for those that are catastrophically injured. Some other benefits that you can claim through the accident benefit system also include lost educational expenses. So if you were enrolled in school at the time of the accident and you're unable to continue with your program, you can claim up to a certain amount. Currently, it's approximately $15,000. You can also claim for transportation expenses and costs related to traveling to medical appointments, examinations, or treatment. There's also housekeeping and home maintenance benefits available, again, to those that are catastrophically injured, or optional benefits. There's also death benefits. Those are in case of a death caused by the accident, payable to a spouse and dependents, and there's a funeral benefit there as well. The other avenue of recovery is tort or litigation against the at-fault driver. And I put on here on the screen here at-fault parties because there might be more than just one at-fault individual. You might have an accident that's caused by several individuals or events, or even deficiencies in roadways or external circumstances that may have caused the accident. So this side is, it takes a bit longer. The accident benefit system, like I said, is no fault and is intended to provide you with some immediate relief, whereas the litigation against at-fault parties, that's meant to compensate you for the shortfall. So things that the accident benefit system is not covering, like the entirety of your income if you can no longer work, we would then claim for that later in the litigation portion of the lawsuit. In order to be successful in a tort claim, you have to prove a negligent breach of some duty of care. So you have to prove liability and fault. In general, drivers owe a duty of care to each other to drive carefully and safely on the road. That's one example. In general, any lawsuit or tort claim will require that you prove a breach of some sort of duty of care and some form of negligence. In car accidents specifically, you will also have to meet the threshold. So you have to be able to show that your injuries are permanent and serious, or that you have a permanent serious disfigurement. And typically the way that we determine that is by ordering clinical notes and records. So if you're involved in an accident, we would order your clinical notes and records from the hospital, from your family doctor, from your treating specialists or practitioners. And that is how we ultimately substantiate the claim and how we determine whether or not you meet the threshold and your injuries are permanent and serious. Once you've met the threshold, the other element that we have to meet is we have to surpass what's called the deductible. So in Ontario, insurance companies have lobbied governments. They are strong entities, and they are entitled to a deductible on any awards for pain and suffering general damages. So if a case was to go to trial and a jury awarded a particular amount for pain and suffering, they are not allowed to know about the deductible. And currently that amount is just over $46,000. So that deductible is applicable if your damages are assessed to be at or under a specific amount. It changes every year. It's indexed to inflation. This year, it's approximately $153,000. So if your damages are assessed to be less than that, your general damages, the deductible will apply. So when we look at viabilities of claim, we keep that in mind. Any sort of settlements also keep that in mind as well, because at the end of the day, if that case were to go to trial, we'd have to be able to surpass that deductible. So what kinds of damages can you claim? There's general pain and suffering damages. That's just the pain and suffering that you have incurred as a result of your injuries. There's also cost of care that we can claim for in a tort action. So that would be things like treatment that you have to receive above and beyond the accident benefits system, mobility devices and assistive aids you've had to pay for, home modifications you have to make. So if you're involved in an accident and now you require the use of assistive aids like crutches or a wheelchair, and you've had to modify your home to make a ramp or to have a chairlift to take you up and down from the first to the second floor, those are the types of modifications that we can also claim for in tort, and medications as well. So medications that are not covered by any plan. The other thing that we factor in terms of income loss is we look at loss of competitive advantage. So that would include things like lost opportunities for promotion, lost opportunities for increase in wages. It could look at things like lost opportunity for particular job bids. If you were looking to change bases or you were looking to put in for a managerial or supervisory role and you couldn't as a result of your injuries, those are the types of things that we could also claim for under a competitive advantage claim. Then we've also got special damages. So that would be out-of-pocket expenses. And as you'll no doubt think by now, there are a lot of things that are affected after an injury that maybe don't initially cross your mind. Of course, there's the acute injury phase and having to recover and deal with recovery from injuries. But then there's also the financial expenses that you have to deal with afterwards. So out-of-pocket expenses could include things like medications that are not covered, treatment that's not covered. So there will be out-of-pocket expenses that are incurred as you go after an accident, as you progress through your recovery. Typically, the standard limitation period if you're involved in a car accident in Ontario is 2 years from the date of the accident. So if you're involved in a car accident, you have 2 years to commence litigation or you lose your right to do so. That's done by way of statement of claim. There's also certain notice provisions for certain benefits. They're more like guidelines, but they are there. So under the Insurance Act, people have a responsibility to report accidents to their own insurance companies within 7 days. Some of these deadlines have strict adherence, whereas others are not very strictly enforced, but the limitation period is a strictly enforced deadline. So that's an important one to know. Then I'll also just briefly touch on the jurisdictional issues I mentioned earlier. I know that some of the membership is working and or living in the region of Ottawa and Quebec. So an Ontario or Quebec resident is not eligible to bring a lawsuit against an at-fault driver if they're involved in an accident in Quebec. So unlike Ontario, there is no tort lawsuit in Quebec if you're involved in an accident. A Quebec resident conversely can bring a lawsuit in Ontario if they are involved in an accident in Ontario. They can also claim under our accident benefit system in Ontario, or they can also claim under Quebec's SAC system. It's very similar to the accident benefit system in Ontario, but it does provide some different benefits. Another type of injury is a slip or a trip and fall. Now, slip and fall, you think classically slip and fall on ice or snow. There's slip and falls can happen for other reasons too. So it could be a defect in design or construction. So you could have a set of stairs that are not up to code, that are not built correctly, that don't have wide enough treads, for example, that are not made with material that is slip proof, that are deficient in their maintenance. So perhaps they're in such disrepair that your foot would go through a wooden deck, as an example. So these types of claims would encompass those types of injuries. We have to show that there's a breach of that duty. Under the Occupier's Liability Act, it defines what that duty is. So it says under Section 3 that an occupier of a premises owes a duty to take such care as in all the circumstances of the case is reasonable to see that persons entering on the premises and the property brought on the premises by those persons are reasonably safe while on the premises. That is a very wordy way of saying the standard is reasonableness. Again, the limitation period for slip and fall or a trip and fall case is 2 years from the date of loss to commence an action. I do want to touch on snow and ice falls. So snow and ice falls are a bit of a separate caveat or issue to slip and falls. So the limitation period still applies, but there's also notice periods that are important to know for a slip and fall due to snow and ice. Slip and falls that result from snow and ice require 60 days written notice to be provided. That has to include the date, the time, and the location of the fall. If you hire a lawyer to, your family member hire a lawyer to help with initiating a claim as a result of a fall, they'll do that for you, provide notice, written notice, but it's important to contact them prior to these notice periods. So they're very short, the 60-day period, and even shorter is the municipal notice period. So for any slip and falls that happen on municipal property, and municipalities are governed primarily by the Municipal Act, there's a different standard that has to be met, and a written notice is much shorter. So written notice is 10 days for a municipal slip and fall. And the standard we have to meet is gross negligence. So it's not just negligence, now it's gross negligence. It goes above and beyond. A lot of people, by the time they come to my office, that deadline has already expired. So it is important to contact someone right away. So dog bites, the applicable legislation for dog bites is the Dog Owners Liability Act. Under that act, it says that under Section 2, it says that the owner of a dog is liable for damages resulting from a bite or attack by the dog on another person or domestic animal. It also defines owner under the act. So when used in relation to a dog, it includes a person who possesses or harbors the dog, and where the owner is a minor, it also includes the person responsible for the custody of the minor. In order to recover anything from an individual, you'd like to think that an insurance company would be there to step in and cover that loss. If they do not have homeowners insurance, though, they don't have an insurance company that will likely cover that claim unless they're a renter who has purchased liability insurance. The limitation period for dog bites is 2 years from the date of the loss to bring a claim. Those are the three biggest. There are, of course, other types of injuries. There's very niche injuries, and by that I mean, and I'm sure a lot of you have seen it all, but there are injuries that are one-offs, things that are rare. There's also other types of injuries that are not, you wouldn't think are necessarily belong in the personal injury world. So for example, LTD denials. I will say LTD contracts are specific. So when looking at a denial, it's important to look at the actual contract itself and why the denial is made. The other types of injuries we have also, unfortunately, lead to fatalities. I wouldn't necessarily call this a type of injury so much as a result. So their fatalities don't mean that you don't have a claim or a cause of action if a fatality has happened. For fatalities, an injured plaintiff is still able to receive general damages, which is payable to their estate. So if someone was injured in some sort of accident and then they decease a couple of years after that injury, they are still able to receive general pain and suffering damages, which is paid to their estate. And family members are still entitled to bring a claim in order for loss of care, guidance, and companionship. So Ontario Family Law Act claims are governed under the Family Law Act, and it allows dependent family members of injured or deceased individuals to make a claim for damages. The Act specifies who is actually eligible, who is a claimant. So it includes immediate family. So your spouse, your children, grandchildren, parents, grandparents, brothers and sisters. And again, they have to have been a dependent. So examples of the types of damages that you can claim as a Family Law Act claimant include expenses reasonably incurred on behalf of an injured. So for example, if you had to pay for medication or assistive devices. Loss of income, if the injured or deceased individual was supporting you financially. Reasonable travel expenses to visit the injured during the course of their treatment. Value of services provided to care for the injured. So what I mean by that is if you're having to provide care for an injured individual, and that's above and beyond what a family member would be asked to or expected to do. So not taking them to an appointment here or there, but actual PSW style care. If you're having to help a family member bathe and use the facilities, dress themselves, you can claim for the actual income that you've had to lose as a result of that. So if you have to lose time from work in order to do those tasks or opportunities that you have to give up, for example, contracts of employment, in order to do those tasks, we can claim for those. Funeral expenses is another thing. And then of course there's compensation for the standard Family Law Act claim, which is for loss of care, guidance, and companionship that the claimant might have reasonably expected to receive from the person if the injury or the death had not occurred. So any of those claims would obviously be subject to the regular requirements to be successful in the claim. So having to prove some sort of negligence and a breach of a duty. So they are subject to a statutory deductible. It's just over $23,000 if the value of the Family Law Act claim is equal to or less than approximately $76,000. There's a precise number that again changes yearly. It's indexed to inflation, but that deductible does apply to Family Law Act claims as well. So when we do look at the validity of a claim and the likelihood of success, we do also factor that into our calculations. So I'm not going to cover the scope of WSIB eligibility or claims today. I'm just going to give you some general information. So workplace injuries, generally the entitlement to benefits are governed under the Workplace Safety and Insurance Act. That act defines who is a worker. So generally that is a person that is employed under a contract of service. It also outlines various industries that are covered by the Act. So those industries are separated into two, what are called schedules. Schedule 1 industries generally include, but are not limited to, mining industries, manufacturing, transportation and storage, retail and wholesale trade, and construction. And then Schedule 2 industries, they generally include but are not limited to provincial governments, railways, telephone companies, some municipal governments, and I say that with a caveat because they can also opt to become Schedule 1 employers. If you're going to pursue a lawsuit for an injury, or if you're going to elect not to pursue the WSIB route and go another route, if you're even eligible to do that, that means then you forfeit your WSIB claim. So you can't have both, it's one or the other. If you're in Schedule 1 and you're involved in an accident with somebody else that is a Schedule 1 employee, you're not allowed to sue. There are exceptions to every rule, and that's why an actual consultation is very important, because the facts of the case matter in terms of eligible routes. And an injured individual may choose the WSIB route, or if they're eligible, they might make a different choice. That being said, internal processes for your employer will have a WSIB claim, that a process that is followed immediately after any workplace injury. So that's not to say that they've done that incorrectly, or that you shouldn't, go through completing the necessary internal processes or forms. I believe it's a Form 7 that you're sent. Those are all normal. So those forms are very normal to see. And just by completing a form, that doesn't mean you forfeited your right to explore other avenues. It's when you start actually receiving WSIB benefits that we're getting into, okay, now you're in receipt of those benefits. Are you still going to be able to take a different route if that's what you so choose? That'll always involve looking at where you're working at the time or where you're not working at the time. And that is an important distinction. And if you were working, was the other individual working, and what schedule did they fall under? And unfortunately, that answer is not something that you can just call someone at WSIB and say, hey, tell me this person's schedule and this person's schedule. That information is not divulged to us. So we have to use other means to investigate the facts of what has happened and assess the risk. So there's going to be risk in choosing one over the other. It's just a matter of calculating that risk and deciding which option would be best. Patients and personal injuries intersect in a couple of ways. The first one being is arriving at a scene and being in a situation where a patient has been injured, whether that's a motor vehicle collision or a fall, or even a sports injury. Essentially, you're the first line that is coming up on the scene. There may have been interactions between the involved parties. There might have been police that has come to the scene. Fire may have been there already. Maybe they've had to do some extrications. But for documentation purposes, the ACR is one of the most important, in my field of work, the ACR is one of the most important tools that we have, that we look at when we assess, one, what actually happened, and two, what were the injuries that resulted. We really look at what paramedics write. I review a lot of ACRs in my line of practice, and we really look at the narrative. So the description that paramedics have given in terms of the mechanism, the reported mechanisms of injury. So of course, if you didn't witness it yourself, you're only going to write down what your patients have relayed to you. All of those details matter because they will speak to, one, liability for us. They will also speak to the nature or mechanism of injury. And they will also speak to what the actual initial reported injuries are. The clinical notes and records from hospitals often don't contain as much detail as the ACRs do. So they are very helpful when we look at them. Another thing we look at on the ACRs are things like the GCS and what was the GCS on arrival. That's important specifically to head injuries. So we want to know what was their level of function when paramedics arrived on scene. We do actually also look at your notes that are listed in terms of what happened between the time that you arrived and the time that you went to hospital. Sometimes patients, when they do deteriorate or they report new symptoms, I find those particularly helpful because When patients have adrenaline running through their body and they're concerned with their acute injuries, they're not necessarily thinking about radiating pain or secondary injuries or limitations to motions, mobility issues. That's not really the first thing they're thinking about. They're just thinking about the acute injury and what hurts the most and what needs attention first. As you go to the hospital, once you've provided initial care and you're on the way, sometimes that changes. So patients may start to describe paresthesia in the hands. They might start to report dizziness and nausea. They may begin vomiting. And all of those help us to reach particular diagnoses. So from that standpoint, as a first responder, it's important to know that your ACR actually does play a vital role, and what we're reading in terms of the symptoms patients are experiencing and reporting to you are instrumental in helping them establish what their injuries are in some cases. As paramedics, you aside from helping them and dealing with injuries and documenting them and providing patient care, you are also providing care to injured patients. And it's important to remember to provide that care within the scope of your practice in accordance with your operating standards. And that's not to sit here and preach, make sure you're following the limitations of your standards or your standard operating practice, but it's more so to protect yourselves and to understand what implications of deviating from that could be. That's also where certain resources come into play. Some resources of which are available through the Paramedic Association. So if you look at the Ontario Paramedic Association's insurance that they provide, I'm not an expert in the actual terms of the insurance, and I'm not an expert in coverage and exclusions to coverage on this insurance. Just for your general knowledge, legal defense insurance will help to cover claims that are made against you, the actual expenses, the costs that you would incur to go through that claims process. And then medical malpractice insurance is important because the scenario I gave you the example of the patient lift. You may, but you may not be covered under your service in terms of liability and negligence. At the end of the day, if you're alleged to have in a civil suit, so I'm not talking criminal right now, I'm talking civil. If you're alleged to have done something or performed an act or provided a medication that was not in keeping with your standard operating practices, you technically can be deemed to have been negligent. Most paramedics, at least that I've encountered, don't even realize the need or the utility of medical malpractice insurance. They think, well, I'm with the service, they're just going to cover me if I'm in a situation like that. And that is not always the case. So it is important to try and protect yourself as best you can. My firm has graciously extended a discount for paramedics and their immediate family members. So if you, I hope you don't need our services, but if you do, then please don't hesitate to call. On initial intake, they would ask you the referral source. You would give them my name, Alexandra McCallum, and you would let them know you are an Ontario paramedic or a family member of an Ontario paramedic. So our firm, the way that we get paid is on contingency fee, which means we take a percentage of any settlement we're able to get on your behalf, whether that's out of court or a settlement awarded at trial. There is no hourly fee that you have to pay. There's no upfront deposit or retainer, as there are in other areas of law. So I do hope that you never have to use our services, but it's always good to know what the legal landscape is like, what types of injuries there even are out there, what kinds of claims you can make or maybe are not entitled to make.
Just as a reminder to everyone, optional with your membership is the paramedic legal protection plan that we have, and that is at a cost, your membership cost of $96 per year, and you can get medical malpractice insurance, an additional $69 a year available to OPA members. When you compare this to the costs that we're spending on our home insurance and our car insurance policies, which sometimes go up into the thousands per year, it is really a small cost to help to keep you protected. So we do recommend that you consider protection for yourself in this increasingly litigious landscape that we are working within. And if more information on any of those policies that we have access to, then there's a lot of information at ontarioparamedic.ca. Alexandra, thank you so much for taking the time today out of your day to speak about personal injuries in and outside of the workplace. We do appreciate you spending some time with us today. And for everyone else who has come as well, to thank you very much for joining us as we provide this lunch and learn. We hope to see you at our next one in the future.
Thank you. Have a good day, everyone.